Family Values Bill, which is before Parliament. You put that to him also, and he raised a few issues. We were under the impression that there was consensus in Parliament and even in government about the current bill. Its status now has been signed off by almost everybody, including the Attorney General. But he tells you in this interview that apparently not. That there are still areas in this bill that will pose a challenge unless Parliament address that. If it goes before the president, he will have no choice than to advise the president to return it. Which aspects are these?
Well, first of all, Evans, it's important to note that the Attorney General is the subject of a lawsuit as we speak. He and the Speaker have been jointly sued because an aspect of this bill, according to the applicant, did not meet the requirements of the law in the Public Financial Management Act 2016, Act 921. Now, the Attorney General points to the advice he gave to Parliament on this particular bill. And even before he started his clause-by-clause analysis in the 18-page advice document that he gave to Parliament, he actually started off by addressing the issue of financial matters by quoting Article 108 of the Constitution, which basically says that Parliament, unless a bill is introduced or the motion is introduced by the President or on his behalf, cannot proceed upon a bill or an amendment to a bill that, in the opinion of the person presiding, makes provision for any of the following. I'll quote them very quickly. In paragraph I, it says the imposition of taxation or the alteration of taxation otherwise than by reduction, or II, the imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction. Now, those two are perhaps the most pertinent to the issue at hand. But it even says in the Constitution that Parliament cannot even proceed upon a motion if it would have the effect of those impositions of charges or taxes. Now, the Attorney General offers his advice. He says, and I quote, "I am of the view that the bill may hold financial implications for the state, particularly regarding A, the collective responsibility of citizens, educational institutions, the executive, legislature, and judiciary to promote the values enshrined in the bill under clause 3 of the bill." He goes on to say the payment for medical assistance or therapy by an approved service provider under subclause 6 of clause 19, clause 20 and 23 of the bill would also have financial implications for the executive. And this one is the most important. C, the provision of prison facilities for persons convicted of an offense to serve their terms of imprisonment in clauses 4, 6, 7, 8, 9, 10, 11, 12, 13, 14, 16, 22, and 25 of the bill. So essentially, the Attorney General advised Parliament that, look, if you want people to be jailed for these offenses that you want to, outlaw, you are imposing a cost on the state. So such a bill must come from the executive, from the president or someone who represents him. If it doesn't come that way and it's a private member's bill as it is right now, then it doesn't meet the constitutional requirements. More importantly, he also quoted Section 101 of the Public Financial Management Act 2016, Act 921, which is the grounds upon which he and the Speaker have been sued.
I see. And you asked him that direct question. So what happens if it's passed in this current state? What would your advice to the president be? And his answer was?
That the president might have to send it back.
I think I expressed a view of it. And for me, my unnecessary view, which is public, is that any law which imposes a charge on the public purse must emanate from the president or a person acts on behalf of the president. That is the clear dictate of Article 108 of the Constitution. And the courts are bound to apply such a provision. So let's see how the courts will rule. It will be dependent on the facts of the case. I indicated that they've taken out certain parts which infringe Article 108, but I still recognize that there are some parts of it which are there. It lends itself to constitutional interpretation.
Putting aside the court case, let's assume that gets dealt with, and this bill makes its way through Parliament.
Right.
It comes to the end of it, and it passes through. and the president now has to assent to it, bearing in mind that it has financial implications on the government, will you advise him to assent to it?
Yeah, but I mean, if it still has financial implications, my advice clearly would be that the Constitution must be respected, and Parliament's attention will have to be drawn to the fact that there are these financial implications for the taxpayer and for the consolidated fund. And for that matter, Parliament will have to take a second look at it. That is what Article 106 on the process of enacting legislations require. That if it comes up to that point that the President has any view of it, he can refer back to Parliament to take a second look at it.
But that would essentially undo all their work.
No, it's not. It's still. So Article 106 does not take away from Parliament the power to pass laws. The President's prerogative in assenting to bills actually only presents a limited way of contributing to a process of passing laws, which is that if it comes to that process, the President is mandated to draw Parliament's attention to parts of the bill that he considers that Parliament ought to take a second look at. Parliament reserves the right to reconsider, or even Parliament can compel the assent through a vote set out in Article 106. That is, yes, I had either to draw the President's attention, the Parliament's attention to these aspects of the bill. Parliament has proceeded to take out some of the things that directly constituted a burden on the taxpayer, which is setting up prisons and medical treatment and whatever. But there is still, I recognize that there is still present the fact that the legislature, the executive, and all persons in Ghana are enjoined to promote the values of the bill. So this clearly will have a tendency to impose a charge on the constituted fund.
Sam George is Member of Parliament for Ningo Pram. He is one of the sponsors of this particular bill. Joins us on the line right now. Mr. George, thanks for your time here on Top Story.
Good evening, Evan. Good evening to your listeners.
What's your response to the Attorney General?
Well, you pulled me out of my campaign. 48 hours. Hopefully, we have our elections on Saturday. I think that the Attorney General must stay focused. I am struggling to appreciate what appears to be flip-flopping on the part of the Attorney General. Because I asked the Attorney General a direct question when he appeared before the committee, and he said he was satisfied that the bill in its current form or shape met all the requirements. I mean, if the Attorney General is coming under pressure from external forces, he should be bold enough to say he's come under pressure from external forces and so he's changing his position, and stop hiding behind what will, in my humble opinion, the greatest of respect to the Honorable Attorney General, amount to very weak arguments. When the Attorney General states that the bill imposes a responsibility on all Ghanaians, including the executive, the legislature, and the judiciary, and institutions of state, to uphold the values enshrined in the law. Why has the Attorney General forgotten the reading of the Constitution? Maybe the Attorney General should go and read Article 39(1) of the Constitution. Everything in that bill derives its source from the 1992 Constitution. Let me read Article 39(1) for the benefit of our listeners. It says, subject to Clause 2 of this article, the state shall take steps to encourage the integration of appropriate customary values into the fabric of national life through formal and informal education and the conscious introduction of cultural dimensions. This is a constitution to relevant aspects of national planning. And it says subject to 2. So what does 2 say? The state shall ensure that appropriate customary and cultural values are adopted and developed as an integral part of the growing needs of the society as a whole, and in particular, that traditional practices which are injurious to the health and well-being of the person are abolished. Except the Attorney General has failed to read Article 39(1) and 2. I don't see the legal logic in the arguments that he's making.
But Sam
Article 39(1) is the directive principles of state policy, cultural objectives. The objects and values in our bill are Ghanaian values that have been espoused by our cultural heads and the national head, House of Chiefs. And so if you say that pursuant to 39(1) and 2, the state, which is the executive, the judiciary, and the legislature, that is what makes up the state. In the bill, you say that they must fulfill their objectives and rules spelled out in 39(1). How does that constitute a financial obligation on them? Is it not an obligation that already exists?
Well, but
is it a new obligation?
But the Attorney General's concern is on that particular clause that still exists. You've talked about, well, the injunctions that society already have on this matter. But what about state institutions like the executive, like the legislature, like the judiciary? All be mandated, to promote.
Were you listening to me when I read Article 39? It
yes,
says
I did.
The responsibility is the responsibility of the state. Let me take you back to your GSS social studies. What makes up the state? Is it not the institutions of state, the executive, legislature, and judiciary? Are those not what make up the state? When the Constitution says the state shall, who is the state? Or what is the state? Is the state not the executive, the legislature, and the judiciary? So what's the point?
Well, the point, according to Attorney General, is you have to balance that with the constitutional requirement that says a private member's bill should not impose financial obligations.
Is this a new obligation that is being imposed?
This does impose a financial obligation.
No.
Whether it pre-exists or not, your bill imposes a financial obligation. That's exactly.
No. Look. If that was the intentment of private members' bills, then there will be absolutely no private members' bill that will meet the threshold.
But that law is in black and white, right? If it's a private member's bill, then it cannot impose the financial obligations on the state.
Is this imposing a new obligation? No. It is not.
But you are interpreting the law that because you believe in your understanding of the clauses that you quoted in the Constitution, it's the obligations pre-exist. Then
if you go and read, listen, Evans, read 108. Read 108 well. Do you have the Constitution with you? If you don't, let me read 108. Let me just pull up 108 for you and read exactly what the Constitution says. You see, 108 talks about settlement of financial matters. That is the heading. You see, people should stop hiding behind legalese. If they want to support the activities of gay people, the Attorney General and the government of President Akufo-Addo should be bold enough and come out and say they support it. But they should stop hiding behind these frivolous excuses. What does 108 say? It is settlement of financial matters. Is this a financial matter? It says Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, proceed upon a bill, including an amendment to a bill, in the opinion, first and foremost, in the opinion of the person presiding, not the Attorney General, the person presiding in Parliament, the Speaker. And then it says, on any of the following: one, the imposition of taxation or the altering of taxation. Does the anti-LGBTQ bill introduce a taxation? Is there any tax element in the bill?
Well, but George, now at least you've heard. I know you have your interpretations. You disagree with the Attorney General, but he's told you that if that part of the bill is not addressed between now and the time it is passed, and it goes before the president in that state, he will have no choice than to advise the president to return it to return it to the House.
That advice will not be based on law. It will be based on the proclivities of the Attorney General and the persons in government who want to support LGBT.
However, you acknowledge it's the president's prerogative to do so, and that's what he's told you it will happen.
But I'm happy the Attorney General, in the interview you played, made it clear to you that the president does not have the final say in that. and that Parliament can compel him to assent to it by two-thirds majority vote. And at that point in time, we will challenge the authority of the president, because majority of the Ghanaian people and majority of members of Parliament on the NDC and MPP side are against this whole matter of LGBTQ. So if the president and a few people around him are pro-LGBTQ and want to take that stand, they will be in the minority even within the president's own government. And that's what I'm saying to you, that the argument of the Attorney General is lacking in legal logic.
Sam, let me ask you. Sam,
108, I'm coming, wait. 1081 that the Attorney General is quoting says that it would fail if it is imposing a tax. Can the Attorney General show you the tax that is being imposed by this bill?
Let me ask you just for clarity. So, do I hear you say that as far as you are concerned, this particular provision, which is still in the bill, will not be changed?
Which provision?
I mean, the part about requiring the executive, legislature, judiciary to promote the values enshrined in the bill, etc., which the Attorney General says currently imposes a financial obligation. You saying this is something you are prepared to touch?
If the Attorney General wants us to take it out, he should bring an amendment to Article 39 of the Constitution and strike that out of the Constitution, because that provision in the bill has been lifted from 39. It is pursuant to Article 39 of the Constitution. So except the Attorney General is telling us that Article 39 is unconstitutional, and if it is, he should take steps to expunge it from the Constitution. Until that is done, the Attorney General's argument has no legal legs to stand on respectfully.
Okay. Sam George, thank you.